Go. It's Bill Gross, the LA probate expert, and I interview real estate professionals and people who are professional that serve our industry to help us expand our business, do better, serve our customers better. We're excited today to have an attorney who's not just an attorney in the local market, not just an expert in the field, but actually was in a class and learned a lot, in particular one niche, the Hegstead petition. We'll talk about that. I'm really excited to have today as our guest, Paul Valasco from Trust and Estates Attorney in Long Beach. Paul, thank you so much for your time today.
Oh, you bet, Bill. Happy to help in any way and answer questions and educate. That's what I do.
Give us a little background. Where'd you grow up, and then how'd you get into law?
Well, I grew up in the Santa Fe Springs Downey area, so I've lived there really my entire life until I got married, and went to school, Loyola Law School. And after graduating, went to go work for a law firm that allowed me to really work in different areas. I worked a little bit in litigation in the beginning, but I really focused more on the transactional side of the law. So I started out doing corporate and business planning, and then tax and estate planning eventually with a tax partner. And that's really what I took to more than anything. I enjoyed that part of the practice, and ended up, when I went out on my own several years later, I decided to focus exclusively on estate planning, probate, and trust law. And that's what I do. So I'm a certified specialist, certified by the State Bar of California as a specialist in estate planning, probate, and trust law. That's all we do.
So I know I saw you speaking at there's a trust administration group in Long Beach that meets regularly, I think monthly or so. Now post-COVID, they're meeting again, live again, where you gave a talk on in front of your colleagues, I guess. I would say also competitors, but colleagues and vendors like me. It was incredibly educational. In particular, that was going into the Hegstead petition. So let's step back for a second. How often do you do those kind of presentations, either online or in person?
Probably a couple times a month, mostly to real estate professionals, tax professionals, and others who ask. People ask me. I don't really particularly care to do one-on-one, like where I'm giving a presentation to the public who are coming in to learn about trusts. I will do that when asked, but mostly I like to educate other professionals who may be attorneys that work in in our area of practice, but also just other professionals, tax professionals, real estate professionals, in which there is a cross between what they do and what we do, trust and estate related work. So really, I like to educate other people on those things.
And I appreciate that, because from time to time I've got customers.
By the way, sorry, go ahead, Bill.
Oh, go ahead.
No, that presentation you were talking about was to the Estate Planning Trust Council of Long Beach.
Right. And
essentially what I was asked to speak about was the most common mistakes that people make when doing estate planning and how to avoid them, right? Especially because a lot of mistakes are made at the planning level. When people are doing estate planning, documents get created, mistakes get made, not just by the attorney, but by the clients themselves. They make mistakes. And so what are the most common mistakes that people make, and what are the ways that we could avoid them? And so that was, I think the talk that you saw, the presentation that I gave. And so,
well, it was great for me because it came up to me with a customer, and they kind of were questioning me. I said, well, no, actually I had the document right here. Here's exactly what this guy does, and you should contact him. It really empowered me to give value to my customer. And I think, and at the same time, support your business. So I just think education is critical. That's why I do what I do here with this channel as well. So just to kind of overview, we had a chance to chat before we started. Really, there's 4 parts to your business, and you participate in all 4 of them. So let's go one by one. Let's first talk about probate filing. So I often talk to either investors or wholesalers or realtors who have a customer who has a property, but there's a title problem. Grandma had the property, didn't deed it properly, and now we have to fix the title. And I call that, that's a title problem solved by probate. So I know you do probate filings and the initiation and opening of probates, as well as getting them closed. Talk a little bit about that business. And I think you really had the key point, which is that a good attorney doesn't spend a lot of time on the probates. They have a great paralegal. They oversee the process. Talk a little bit about your probate business and how you create value for customers.
Yeah, so probate is simply the process by which a person's final affairs are settled when they die. So if somebody dies without having done proper estate planning, and the reality is most people don't. Most people, I would say 65% of Americans in general, do not have an estate plan. So when people die and they have assets in their name, property in their name, before it goes to where it's supposed to go, right, to their heirs or their children, their family, it's got to go in California, it's got to go through a court process. And that process is called probate. The purpose of probate is actually good. I mean, the purpose of it is to settle a person's final affairs. Somebody passes away, they've got property, bank accounts, investments, other assets in their name, and those assets have to get somewhere. They have to get to the right place. But before that happens, their final debts, taxes, and expenses have to be paid. And so probate is the process by which that is done. An executor or administrator is chosen to have control over all the assets, collect the accounts, collect the stocks, marshal the property, sell things, again, pay off debts and taxes, and then distribute whatever's left to the people who are entitled to it. So those are actually good things. It's a good purpose. The problem with probate is that probate is the most time-consuming and inefficient way to do it. There's a better way to do it, if you can. But for those people who have to go through probate, the idea is that basically you have a court who appoints an administrator. That person has the duty and responsibility to settle the affairs and get the probate distributed. It takes about anywhere from 12 to 18 months to do a probate, assuming there's no litigation or no other issues going on. And so the timing of that, it's time consuming, and it's also expensive because the fees are based on the size of the estate. So the larger the estate, the higher the fees. There's a percentage calculation that's done. And so, an average of $1 million probate, for example, the attorney's fee is $13,000. I'm sorry, $23,000. So for $1 million probate, which nowadays, if you have a house in California, you're going through, it's going to be $23,000 for the attorney, $23,000 for the administrator, and maybe $4,000 or $5,000 in court costs, filing fees, publication fees, court appraisal fees. So it all adds up. And before you know it, to go through probate in California, your family's paying over $50,000. So that's what we're trying to avoid.
And it's interesting because people talk about how expensive the attorney's fees are, but when it comes time for somebody else to administer the probate, and I'll say to them, well, you can take a salary. Well, that sounds like way too much work. Well, what do you think it is for the attorney? It's a lot of work. There's a lot of details.
It is.
Now I think the key that you hit on is if you have great staff and you can do a volume of these, because you can't have great staff and do one a year. If you have a certain volume of these and you have great staff that can do it, then you can be more efficient and I think give the customer a better outcome. So as a businessman, how do you manage that process?
Yeah, so look, much of the work that's done in probate is administrative documents, forms that need to get filed and filled out, and those are forms that are repetitive. So, any good paralegal can handle the trust. In fact, my paralegal, who's been doing this for more than 20 years, really probably knows more about the probate process, the time frames, the little forms, things that come up and have to be filed, knows more about that than I do, and he should. I mean, this is what he deals with every day. I really am the only one. I'll go to court and I get all the glory, but really all the work is done behind the scenes. They're the ones that are behind the scenes in the trenches, dealing with the clients, gathering the information, and putting that together, which is good because that means that it's not an attorney charging at attorney rates to do that. We're a lot more efficient by being able to give it off to a paralegal who can do that. And so we have a great staff to work on probates, and that's really their full-time job. We have a full probate department. That's all they do is probate work, and they're very, very busy.
If I can correct you, I don't think any paralegal can do this. I think any paralegal could be trained to do it, or any paralegal can get the experience to do it. The problem is 9% paralegals don't do but a probate a year. That's a prescription for a mess. And I see that all the time. They can be a great paralegal. They could be the world's greatest paralegal on constitutional law or DWI. You give them a probate, you're going to have a mess, is my experience.
That is so true. But it's important because paralegals are really worth their weight in gold. If you have a good paralegal who's well trained, knows what they're doing, and has an attorney with whom they are working under, that is really worth their weight in gold because they can do work. I really will put up my paralegal, my senior paralegal for probate against any attorney who does probate. I've had other attorneys call and ask to talk to my paralegal, whose name is Tim. To say, hey, I had a question, and sometimes I won't know the answer. It's like, talk to Tim, and Tim will know. So it's important to have that, those administrative staff who are able to do that, and like I said, do it efficiently. But you're right, it's not going to be knowledge that they just glean by doing one a year. And unfortunately, there are a lot of people out there who call themselves like document prep companies, and people who are maybe paralegals who are just working on their own and not working under attorney. Right. And mistakes can be made. So it's definitely important that if you're using a paralegal, that they have expertise in what they're doing, that they're working under the supervision of an attorney, and they have experience.
So important. You're right. And even attorneys, there are a lot of great attorneys. And again, they could be the world's greatest attorney, but if they only do one probate a year, how good can they be, and how good can their staff be? And that's always the challenge, is working with an attorney who it's hard to get them to understand what they don't know. But that's a whole nother discussion.
That's true, but that's why I chose to focus exclusively on trust and estates. I mean, the days of the general practitioner are really gone. You really need to specialize. I mean, my opinion is that in order to be good at what you do and become an expert at what you do, you need to specialize in a particular area of practice. Because if I were having to do also, when things come in, family law or criminal law, or, bankruptcy, there's just no way I would be smart enough to be able to get all that information, everything I need to be an expert for my client in all those different areas. And so specializing in one particular area, I mean, there's enough to know just in this area of practice, right, to take up, more time than I have in a day. So
it's also to get the experience in all those areas. I think sometimes attorneys, again, I meet them and they're very well educated and experienced in a lot of areas of law, but there's a difference between them and you, where you've been in the different departments of probate in LA County. The judges, they have some discretion. They know who you are, and they're going to give you a little bit of a break to get something approved versus an attorney they don't know. I've seen it. They're just not going to give that attorney the same leeway or discretion that they're going to give you if they respect you and see you regularly. So all that's on probate, which is what we want to avoid. And the way we avoid probate is through proper estate planning. So talk a little bit about your firm and how you help families avoid probate and get the best outcome kind of ahead of time.
Yeah. So, well, one of the things that's most important about estate planning is education. And that's why I give presentations. I don't charge people to give presentations. I do it really because, it takes up time, right? To prepare for it, to go attend these things. But I think it's so important, education. I don't charge for consultations either. So initial consultations. So because somebody comes to see me, whether it's for a probate or trust administration or estate planning, I think education is so important. They need to know what their rights are. They need to know what the processes are. And once they're educated, knowledge is power. And so they'll be able to, hopefully be empowered to move forward and get things done. And if we're there to help them, we're going to help them. But so educating people in estate planning is important, because most people that don't do estate planning, and like I said, the majority of Americans don't. And the reasons for that are two. Number one, procrastination. People they know, they think about it, they've been told about it, but lives are so busy with their family and work and everything else they got going on. Sometimes it takes like some death in the family or some tragic situation to bring their mind. Like COVID, for example, was a big eye-opener for many people, where before people, even younger people don't really think about death much. And then COVID hit and people started thinking about their mortality more and realizing, hey, they've got to get something in place. So sometimes that's what it takes to get people off that procrastination mode. But also the other reason that people don't do it is lack of knowledge. They just don't understand. If everybody knew what their family is going to have to go through, what it's going to cost them, and the toil it's going to take to go through a probate, they would not force their family to go through that. They would be planning. So that's what the important thing is, getting the word out. And really, the most common comment I get after all is said and done, when I meet with clients and do their estate planning, is the most common comment I get is, this was easier than I thought it was going to be.
Oh.
People have built up in their minds that it's going to be so complex and they're not going to really know, and they're going to have to gather all this information, and how are they going to do that? They really, are intimidated by the process. But once they realize, after speaking with me and getting educated about what it entails, it's not really that difficult. There are going to be some things, some questions you're going to have to answer, some decisions you're going to have to make, some maybe things you're going to have to face that a lot of people don't want to talk about, right? Nobody likes to talk about death and mortality. But, those are things that you have to think about. It's going to happen for sure. So it's just a matter of planning for it. And so we sit down with clients. Our process is simply this. Client calls us, they want to do some estate planning. And so we send them out a questionnaire. Questionnaire is very simple, just basic information about their family and financial circumstances. What accounts do they have? What investments do they have? Stocks, real estate, and the names and addresses of their family. So they bring that questionnaire with them to the meeting. We sit down, we talk about, just like we're doing now, we just have a conversation about what estate planning is, what it entails, and essentially that we're trying to avoid the court processes when you pass away, and have a plan in place that says, if you become incapacitated right before you pass away, if you have an accident or an illness and you're not able to manage your own financial affairs, an estate plan is going to allow you to pick the people that are going to make those decisions for you, healthcare decisions, financial decisions, managing your property if something happens and you're in the hospital. And then at your death, there's a plan for the distribution of everything in accordance with your wishes in a way that avoids the court processes or probate. So we talk about that and educate them. We answer their questions. We determine what's their family situation, right? Are they long-term marriage with children of the same marriage? It's a blended family situation where each of them have been married before and they have children from different marriages. So all of that has to be, the plan, if it's done right, has to be tailored to their personal family and financial circumstances. And so we educate them, answer their questions, gather the information, then we do we prepare the documents. So wills, trusts, power of attorney, advanced healthcare directive, the deeds for transferring their property. So we prepare these documents, and then it takes us about 2 months from the time that we meet with them to put all that package together. We get together a couple of months later, they come into the office, I review everything with them in detail, and then they sign all those documents. So, they'll end up leaving our office with a complete and comprehensive estate plan, covers all the bases. So, and a lot of people, it just gives them peace of mind, right? I mean, like life insurance, you hope you never have to use it. With an estate plan, you are going to use it someday.
At some
hopefully
point.
it'll be many years in the future. But it'll give you peace of mind to know that there's something in place. People tell me all the time, they'll call me saying, we're going on vacation in 2 weeks. Can you get this done for us? So that's when people think about it. They're going to fly somewhere, they're going to take a trip, and they're thinking, what if something happens, right? But if you have an estate plan in place, that peace of mind is always there.
So I know that there's a wide spectrum of service in estate planning, from self-help, very inexpensive, very routine, to highly customizable. Where in that spectrum is kind of the majority or the best fit of clients for you? What's a typical or most common? I know you do some that are lower income, and we all would like to do some business on the higher end. But how would you describe kind of the fat middle of your business as far as estate planning? What's the most common scenario, assets, and family situations you deal with? Right.
So I would say the average client of ours has an estate size somewhere between maybe $2 and $12 million, right? So that's the average. There are some clients who have less than that and basically just have a house and a bank account, and they want to make sure that their estate doesn't go through probate. And others who have much larger estates, over $100 million, and they want to not only plan for the distribution of their estate in a way that avoids courts, but also maximize the amount passing to their children and minimizing estate taxes. So intergenerational family transfer, wealth transfer. So we help clients with those issues as well. So really, the spectrum for us is wide, but in terms of average, our sweet spot is clients anywhere between $2 and $12 million.
Got it. So now we covered probate, we covered avoiding probate, which is the planning ahead of time, estate planning and such. But occasionally there's disputes either in probate court or even with trusts. I see regularly there's disputes, and that's where litigation comes in. So what portion of your practice is litigation, and how does that kind of figure into the rest? To my way of looking at it, if you're a litigator, you see the effect of mistakes. And I know I saw your presentation, you talked about one of those, and I thought it was fascinating that, of course, you want a litigator who's involved in designing the documents or amending the documents, because they know, I was in court last week and this caused a problem and we want to avoid that in our documents. Explain how the litigation kind of fits in.
No, that's exactly right. That's exactly right. I mean, being able to be on all sides of the transaction from beginning to end, right? From the time you create the estate plan to the time somebody becomes incapacitated and then ultimately passes away, you're able to see the full gamut of the impact of what you do, of your work, or the work that maybe some other attorney did, or some other planner did, or people who go online themselves and try to do it themselves and the mistakes that they make. And so you're able to see it from beginning to end. Now, many attorneys who work in my area of practice do exclusively estate planning. That's all they do. They just want to do the transactional stuff. It's certainly, from a perspective of an attorney, it's much less stressful. You don't have deadlines, unless self-imposed deadlines. You don't have court deadlines. You don't have the stresses that come along with litigation. And being a litigator, you have to have more resources. You have to have staff. You have to have paralegals and legal assistants who help with all of that. So that's, higher overhead. So many people who work in my area of practice do only the transactional side of things, the estate planning. What makes us a little bit different, and I think what gives us an advantage, is that we're able to see, like I said, all sides of the transaction. We're able to see the result when somebody passes away. What happens with the administration? Was this plan done correctly, or are there mistakes? Are we now ending up in litigation because of mistakes that were made? Now, litigation can come about not because of mistakes. It can come out because people are just unhappy. Family members are unhappy with each other. They'll find ways to have a dispute or to fight about things. People will contest wills or trusts, even though they were properly done. They'll contest them, for settlement value. So there's certain types of litigation that no matter what you do, you're not going to be able to control. You can't control what other people do at the end of the day. But many of the reasons that we're in court, either because there's disputes or because the documents are not done correctly. So when we're in court, it's not always because there's litigation going on between the parties or there's this dispute. It's because things were not done correctly. The documents don't accurately reflect what was intended. Maybe they're ambiguous. Maybe the trust was not properly funded, and now we have to go to court to resolve these things. So there are many reasons to be in court. But because we see that too, we get to see the end result of that, and we deal with these problems, like you said, on a daily basis. It makes me a much better planner. I now have experienced many of the things that people, when I meet with, talk to me about, right? Blended family situations where when somebody dies, what the issues, the disputes, the problems are going to be. So in the planning, I make sure that I do things within the plan to minimize the possibility of those things happening, right? To anticipate that. And so it makes you a much better planner when you're able to translate what you do in court versus the transactional side of your practice. So I think it gives us an advantage over many other firms who just do estate planning.
And I, begrudge somebody who doesn't want to do those other areas. I mean, we all have to make our own, career decisions. But I know as a professional in the business, I just really admired that you did that full circle, because I thought it gives you visibility, and in the changes. There might be things that were great plans when you wrote it 5 years ago or 3 years ago, but the law changes or courts change or politics change, and all of a sudden you have to pay attention to something. And I think the litigation gives you real world feedback as to what has to change.
It does. And sometimes it is the law that changes in a way that, requires you to kind of change your thinking and maybe change some of the provisions in your trust. Cases come down from the appeals courts and you maybe have to make tweaks here and there. But really the most common changes that come about in estate planning, the most common reason people do amendments or changes to their estate plan is because of changes in their family and financial circumstances. So changes in the relationships with the people that they've chosen to be successor trustees and executors and agents under the power of attorney, or with people who are going to be inheriting from them, and they want to make the changes. So, one of the common mistakes that is made in estate planning is the failure to review your estate plan. So many clients have done estate planning, but maybe it was done 5 years ago, 10 years ago, 15 years ago. And it's likely that those plans do not reflect, what their current wishes are. So it's so important to review every few years. So we send a letter out to our clients every couple of years to let them know, hey, it's been a couple of years since you've done your estate planning. We should, schedule a time to have a review your trust. It may be that there's nothing to change, that everything is fine. But it also gives me an opportunity to see what assets have you acquired in the last couple of years? Have you acquired new properties? Have you opened up new accounts? Do you have new stocks? And how did you title those? Did you put those in the name of the trust? Because that's a common mistake people make, is they acquire new things and they just forget to put it in the name of their trust. They just put it in their individual name, as they always do. And of course, that could be a problem later. If they pass away and those assets are not in the trust, it's going to be a court proceeding later to get them in if they die without having made that transition. So it's important to do a review, to review your estate plan at least every couple of years.
It's not a problem if you left something out. You just have to go. It's the equivalent of going to the DMV and asking them to change the title on a car, except for it's a lot more expensive and it's not as fun as going to the DMV. So that's why
exactly. Yeah, and that's assuming that you have the right provisions in your trust that allow you to do that, right? Because you mentioned the word Hegstead before, but let me explain the situation and how it comes about. So often many people choose to do estate planning they either, well, like I said, sometimes they'll do it themselves. They'll get online, they'll go through LegalZoom or Rocket Lawyer, or they'll go to these paralegal outfits like We the People or others who will do these doc prep for them. And often in those situations, because it's just ignorance and just lack of the knowledge, they don't properly fund the trust, right? It's not enough just to create a trust and sign it and put it away. You can do that with a will, because a will is only effective at death, right? You're signing your will, you sign it, you put it away. Hopefully it'll collect dust for many years and you won't need to bring it out. But at some point when you pass away, that's when it becomes effective. But a living trust is effective immediately. When you sign it, it's a contract, it's now in place. And in order for it to work properly, you have to put your assets into the name of the trust. That's the way you avoid probate. Probate is about getting control, right? Because when you pass away, if you have assets in your name, bank accounts, investments, stocks, real estate, those financial institutions are not going to give your family access. They're going to say, well, what happened to these people who are on the account? They passed away. Well, you're going to have to go to court. Same thing with the title officer, right? It's going to tell them, oh, this is in their name. You're going to have to go to court. But if instead those assets are titled in the name of a trust, a family trust, then those financial institutions know we don't need court. We just need to know who's the trustee of the trust. We need to see a copy of the trust document. So creating the trust and then putting your assets into the trust is what makes it effective. It gives the people who are in control now, your successor trustees, the power. They can literally take that trust down to the bank and go and collect money that's in the name of the trust. They can do the same for stocks and investments. They can record deeds that give them control over the real estate that's titled in the name of the trust. No court proceeding is necessary. We don't need to go to court and get permission or power. It's all contained within the trust if the asset is titled in the name of the trust. And so the common mistake that is made is people will do a trust and either from the beginning just fail to fund it. They don't change the title on their property. They don't go down to the banks and change their accounts. They just leave things in their individual name, or they'll acquire new things, new properties, new investments after they create the trust and forget to put title in the name of the trust. Another common mistake is that people will refinance their property.
Classic.
In the trust. Classic mistake. It comes out of the trust in a refinancing. Sometimes nowadays they'll actually refinance it within the trust and you don't have to do that, but often they still require that. And when it comes up, and all those documents that people sign in a refinancing, you know, people don't read those things. And one of them is actually a deed that takes it out of the trust, puts it back into their name. And then after the refinancing, it never gets put back. And so now a property that was once in there is now outside the trust without their knowledge. They pass away. And then these assets that are not titled in the name of the trust, they're subject to a probate, right? Things that are in your name are going to go through probate. Now, when you do estate planning properly, you also create a will. So all my clients who have trusts also have a will. The purpose of the will is the backup document. It says that if I pass away with anything in my name, then that will catches it and it leaves it into the trust. It's called a pour over will. So the idea is catching whatever is left out inadvertently and puts it into the trust. The problem is that all wills are subject to probate, even a pour over will. So that if we don't have the right provisions in the trust, then that will is going to be used to file a petition for probate with the court, to get the court to appoint an executor who will have control over that property and then put it into the trust because that's what the will says. So the whole purpose of doing that estate plan, that trust, was to avoid that. But now because of the improper titling of property, lack of funding, failure to fund, it's going to go through probate. But there's a way to avoid that. In the 25 years I've been doing this, not one time has my estate trust that I created have to go through probate, even when my clients make mistakes. And they do. People just make mistakes. They forget, they leave things out. So the reason for that is because we rely on this case that you referred to called the estate of Hegsted, right? That case is a case that was decided back in 1993, many, many years ago. That case is available to be used if it's used properly. But what happened back in 1993 is Mr. Hegsted did a trust. He created a trust in which he put all of his assets into the trust. He titled all of his properties into the trust except one. There was one property that was inadvertently left off. And so he passed away. That property was sitting outside the trust. Normally, you would use his pour over will, which he did have, and probate that and get that into the trust. But instead of doing that, the attorney for the estate made a novel argument with the court. Instead of filing a petition in the probate court, the attorney filed a petition in the trust court and asked the court, the trust court, to recognize Mr. Hegsted's intent. The intent was that property was supposed to be part of the trust. How do we know that? Because at the back of the trust, in the schedule of assets, he made a list of everything he intended to include in the trust. And one of those was that property. And so the attorney asked the judges to recognize that as being a funding of, actually his intent was to put that in the trust, recognize that intent, give us an order today that says it's part of the trust so that we don't have to probate it. And the court agreed. The court granted that petition. So that set a precedent, 1993, in which the court agreed that now, as long as we know what the intent of the creator was, we can get property in the trust that wasn't properly titled there at the time of death. And so after that case, what should every trust have? Every trust should have a schedule of assets that we can point to, and it should have a statement of intent. So I'll show you, I'm going to share my screen and show you what I'm talking about. So let's see if I can pull that up. All right, here it is. So this statement of intent is what we include in all of our trusts. So all of our trusts have a statement of intent. It simply says, look, the primary purpose of this trust, the main reason for doing it is to have an estate plan that says where my property goes when I die in a way that avoids probate. And therefore, I intend to keep my trust funded throughout my life with all my assets. However, if I make a mistake, if I inadvertently leave something out of the trust, then I want the court to issue an order along with that case, the estate of Hegstead. So I cite that case, and there are several cases that follow that stand for the same proposition that as long as we know what the intent was, we can avoid probate. So I make it clear to the court, my intent is to avoid probate. And therefore, if I make a mistake, give me an order later, like you did in that case, the estate of Hegstead. And then I do what that case did. In all of my trusts, we have a schedule of assets. We list all of the accounts, the investments, property, anything they may own at the time of their death, we put on that schedule. Not only that, we go the extra step of including a general provision or a general assignment that says, not only these things that I've listed above that I own today, do I consider to be part of my trust, but anything else I may acquire in the future, such as real estate, investment, stocks, life insurance, partnerships. In other words, a non-exhaustive list of things they may acquire in the future that they would also intend to be part of their trust. So I've helped clients in situations where they acquired the property later, so it wasn't on the schedule, but they acquired it later and they forgot to put it in the trust. But because of this catch-all provision in the trust, I'm able to still get that in. And that statement of intent helps as well. So this is what I'm talking about. These are the provisions that need to be included in the trust in order to take advantage of that case and avoid having to go to probate. But, you know, unfortunately, most trusts do not have these provisions. Most trusts do not have a statement of intent. And if there is a schedule of assets at all, it's maybe a schedule that was, 10 years old and doesn't have the assets that we're looking for to try to get into the trust. So many situations end up going through probate anyway. So a big common mistake is people did a trust thinking that they were going to avoid probate, and they end up having to go through probate anyway. And if you have the right provisions, even if you make a mistake, we can avoid that.
I've literally seen cases of this where I have a client who maybe has an ex-wife with a child or whatever, somebody else who could make a claim on the estate, and because the trust had a list of assets that specifically left this property off, for whatever reason, usually because it was acquired afterwards. They didn't have the statement of intent that you have there. And it certainly wasn't as, the intent, look at your document, it's pretty obvious. The intent was anything I ever have or will have or should have had, or you're basically saying anything as long as you can at the top of your lungs. But I've seen other ones where they just list 3 or 4 properties or 3 or 4 assets. Right. Well, it doesn't have the same impact, and a judge now has to determine what was the decedent's intent. In your case, intent's pretty clear. They want everything in the trust, whatever they can do. They paid you. They hired the best attorney to give them the best plan to do that, versus when it's just 3 or 4 houses that are listed. If there's a 4th property, that other party now can make a case, and now you're chewing up the legal fees, the assets that you wanted to pass on to your family members. So I've seen this in action on the flip side. That's why I'm so really glad to have a chance to chat with you today.
Yeah, and look, judges want to be liberal about that. They want to, they don't want the family to have to go through probate. They're trying to get a decision, but they're bound by these court decisions, right?
Right.
So not all cases fit within that. You don't have the facts. The court's not going to just have mercy on you and say, I was in court last week and there was an attorney who was trying, it was actually two different cases. One attorney was trying to say, well, there is no schedule, but he had the pour over will. And so the will evidences the intent that everything's supposed to be part of the trust, but that's not the case. The court pointed out clearly that that's not the holding in Hegstead. Holding in Hegstead is as long as the trust document itself or some assignment even outside of the trust, outside of the will, would show the intent that that was to be part of the trust, then we can do that. But the court denied that petition. On another one, again, there was a schedule of assets, but it didn't have that property.
Right.
And
Classic.
so court denied it. So the court's trying to be liberal, but at the same time, so when you give them something to hang their hat on, like we do here, where they have the statement of intent, they have a schedule of assets, they have that statement that everything that they acquire in the future to be part of that trust, it's an automatic, it's a slam dunk. And so,
well, I think, like you say, the judges seem to want to carry out the decedent's intent, but you have to give them a pathway and something to rely on to get there. But the problem that the other case has is, that attorney might have had a 50-50 shot of getting it. You don't know. The judge has the discretion, as you know, to approve whatever they want. And the attorney has no way to know what the judge is going to say, but it's going to cost you $10,000 or $20,000 to get there to find, and about 6 months to a year to find out the answer. Whereas if you planned ahead of time and had all of your ducks kind of lined up, you give yourself a much better chance of the outcome that you want to expect.
No, exactly. And both of those attorneys were very disappointed, arguing, not arguing with the judge necessarily, but just stating their case and trying to persuade the judge. And, judge just very calmly just said, I'm sorry, you're not persuasive and you don't have the case law that supports what you're asking for. And so they both walk away. And the problem is that now you file this Hegstead petition or this petition to confirm trust property that's now denied, and now you have to go through probate. So you've done one proceeding, been shot down. Now you've got to go file a petition for probate, and now that's another year process. So yeah,
and maybe go before the same judge that already doesn't look at your work. If you did the trust, they're already thinking you're a little shoddy. Your arguments, or maybe you push you push things a little bit, and they're not exactly friendly with you now. And now you're going back to them for probate. So that's why it's best to get all the stuff done in the first place. It
is best to do it right in the first place. And just like anything else in life, when it comes to estate planning, if you're going to do it, just do it right. Don't try and cut corners. Don't try and do it yourself. You wouldn't, perform surgery on yourself. These are assets that you've built, you've spent your whole life building for you and your family. And it would be a shame to just, put that all in jeopardy because you want to save a few dollars. And I will tell you, people who think they're saving money by going to, a paralegal and getting it done or doing it themselves, in the long run, in many, many situations, they're not. They're just costing their family more money.
Yep.
Because when those things go wrong, which they often do, you're going to end up in court anyway. Sometimes it's better had they done nothing than what they tried to do. Because of what they've done, sometimes there's a dispute. There's ambiguity in the document. It's not clear what was intended. And if you interpret it in one way, it may help some individuals, and interpret it in another way, it helps somebody else. And now everybody lawyers up and you're in court. So it's important to just, like I said, go to an expert who knows what they're doing and just get it done right.
So speaking of an expert, if someone wanted to get in touch with you, you mentioned free consultations for estate planning, for example. Your website is velascolawgroup.com, and there's your phone number as well, and details and such. And there's your handsome picture, looking very good. And so somebody has questions about you, the best way to reach you would be to call that number and set an appointment with you or your staff and see if they can, if you can help them.
That's right. Yeah, just give a call. Our staff is there to help. We are fluent in both English and Spanish. And so we do a lot of work in the Latino community, which is a very underserved market. And for some reason, there are very few Spanish-speaking estate planning attorneys out there.
Yes, yeah, you're right.
And even fewer certified specialists. So we help clients, all of our staff that answers the phones, greet people, speak Spanish. And we have, several attorneys that are fluent in Spanish as well.
In particular, I've seen in the Spanish-speaking market, that trying to do their own avoiding of estate planning through creative title holding. I'm sure you've seen some of these deeds to family, mom's sick, so we'll put the sister on, we'll take her off, we'll put her on. There's tax implications and legal implications. And so you're right, that market is very underserved. I would do this interview in Spanish, but I passed a Mexican food restaurant menu. I really don't, my Spanish isn't very good. or flirting with girls. Other than that, I really don't speak much Spanish. So I can't help with that. Other than say, call Paul Valasco, and there's his phone number, and I can say it in Spanish. So other than that, I can help.
Yeah, but you're right about people trying to do like self-help with estate planning and taking shortcuts and using deeds to try and accomplish their planning by adding family members and others to title, right, as joint tenants. And I mean, I just have so many stories about things that have gone wrong when you add children to the title or anybody to the title of your property. People have one of the problems, of course, is that when you add somebody to the title of your property, their problems, whatever they may have, whether it's a judgment against them, somebody's collected, you're going after them, somebody sues them, they're going through a divorce, any number of problems that can happen, their problems are now going to become your problems because those things are going to attach to your property. Right. The other thing is that you don't know what your relationship is going to be like with these people in the future, right? Even family members. You put somebody on title and sometimes people do it for convenience, or they're adding them to title for loan purposes, or they're just thinking, if I pass away, I don't want it to go automatically. I don't want to have to do a will. But then if there's a falling out with that person and years later, you're trying to call that property back, many times they don't. They will not give that property back. And now you end up with the prospect of a parent having to sue their child to get their property back. So we've done that on many occasions as well. So it's not a good idea. The worst thing to do is to use joint tenancy for estate planning.
I see that all the time in my world. So, okay. Well, look, Paul, I really appreciate your time today. And I also appreciate your willingness to educate and help people. And I know, I guess I learned a lot. When I say the first time, I've certainly learned a lot from our conversation today and look forward to the future. So thank you so much for your time. I really appreciate it.
You bet. Thank you, Bill. Anytime.